Welcome to Employment Law This Week. I'm George Whipple. Last month, the California Privacy Protection Agency Board met to discuss several new regulations that could impact employers in California and beyond. Among them were draft regulations for automated decision-making technology, an initiative that's part of a larger trend across the country to regulate the use of technology in the workplace. The draft defines automated decision-making technology, or ADMT, as any system that processes personal information and uses computation to facilitate or to make decisions. Epstein Becker Green's Nathaniel explains what the definition covers.
That will include anything of a software-based nature, such as AI, machine learning, statistics, or data processing techniques. And under the draft regulations, businesses that use ADMT will have to provide certain notice and opt-out rights to consumers. These regulations will impact employers that use AI and machine learning and similar techniques to make hiring, promotion, and other employment-related decisions. These draft regulations are not formal rulemaking by the board. They are simply meant to facilitate board discussion and public participation. But I think it's really important for employers to understand the ways in which they implicate how the agency views consumer rights and also employee rights in the age of AI and machine learning. Given the fluctuating state of the law, the many proposals in California and elsewhere, it really is imperative that employers gather a group of key stakeholders to understand what type of sophisticated technologies they may be using, and also work with counsel to understand the various implications of this and other potential laws and regulations going forward.
The board also discussed the latest draft of the new cybersecurity audit regulations. Epstein Becker Green's Brian Cesaratto is here with details about this proposal.
It would cover at a business level, generally organizations that do more than 25 million in gross annual revenues and process the personal information of 250,000 or more consumers, meaning California individuals, in the preceding calendar year, or process the sensitive personal information of 50,000 or more consumers or 50,000 or more children. The board finds that the processing activities of these businesses present a significant risk to consumers' privacy and cybersecurity, underpinning the requirement for an audit. The audit would require an independent and well-documented audit of the elements of the business's cybersecurity program, including strengths and weaknesses. The first audit must be conducted within 24 months of the final regulations and then annually thereafter, and the business must certify to the board the completion of the audit requirements. The CPPA staff will revise the regulations for readability and clarity, and then after the board approves those changes, the regulations will proceed to formal rulemaking for a 45-day public comment period. Ultimately, the cybersecurity audit regulations, as of today, appear to be in near final form before public comments begin. If you look at statutory and regulatory activities across the nation, including in critical infrastructure industries, there is a clear trend toward imposing minimum specific cybersecurity standards.
Thanks, Brian and Nathaniel, and thank you very much for watching. We'll see you next time.